very good morning. I'm Helen Farr. I'm chairing today's session. Now today, as always, we're going to have a really packed programme. And we're going to start with Tom Pennington-Hare, who's going to be looking at redundancies. And I know that this is obviously a perennial issue for lots of you who work in HR. He's going to be dealing with lots of issues that you'll need to think about and give you a case roundup on particular topics. And then we're going to move on to something completely different, which is dress codes. And Parissa is going to be looking at, in particular, some of the issues that came out of the government's review into dress codes last summer. I think lots of you will remember the case of the receptionist who was sent home by PwC for wearing, or refusing rather, to wear high heels, and the uproar that caused. So lots of pointers on dress codes, what to do in terms of wearing religious symbols at work, whether that's appropriate or not, and of course the perennial issue of how to deal with dress down Fridays or dress down days generally. And then we're going to break for coffee. After coffee, we're going to move on to two really important topics. The first is GDPR. And I know that lots of you will be starting to think about this if you've not already done so. What do you need to be doing as HR professionals for your business to get ready for GDPR? We've got just under a year now to get ready. The new regime comes into force on the 25th of May next year. And Nigel, who is our privacy expert and leads our group, will be looking at some of the pointers that you need to think about as HR professionals. And in your pack, there is a flyer that Nigel and I prepared, which really gives you sort of 7 key areas that we think as HR professionals you need to be focusing on to get your business ready for GDPR. So if anyone's got any questions, please speak to Nigel or me in the break about that in particular. And then the last topic will be tax. We have to cover it. There's been a lot of new developments relating to employment tax. And Emma Bailey, who is a partner and heads up our tax team, will be leading us through that.
Morning, everybody. I am looking at the tricky issues in redundancy. So I'm not proposing to go through the nuts and bolts of how to run a redundancy process. Instead, I've picked what I think are maybe the top 5 tricky issues in redundancy situations, and I'm going to spend a little bit of time looking at each of them. I'm aware, though, that it may have been for some of you sometimes since you've had to go through, or rather run, a redundancy process, and for others it may be an issue that you haven't had to tackle yet at all. So before we look at the tricky issues, I thought a brief introduction would be a good idea. So I'll spend just a couple of minutes looking at the legal definition of redundancy and then provide a very basic overview of a typical redundancy process. So what's redundancy? Well, the legal definition is set out in the Employment Rights Act. It's long, it's a little bit technical, and I thought that it wouldn't be fair to inflict it upon you first thing this morning. So instead, I've set out what I think are the 3 areas that it covers. The first is where there's a business closure. So in this case, the whole business is closing down. It could be, for example, because the employer's gone into administration. The second situation is where there's a site closure. So, for example, a particular factory or a particular office is being shut down. And then the third situation is where the employer has a reduced need for employees to carry on work of a particular kind at a particular place. And so in this case, the business is still going, there's no business closure, no sites are shutting down, but yet the employer has a reduced need for employees to carry out work of a particular kind. This could be because of a downturn in the market, or it could be because a labour-intensive process requiring several employees has been replaced with a mechanised one that perhaps only requires 1 or 2. Another key point to note is that redundancy is one of the 5 potentially fair reasons for dismissal. But in order to avoid liability for unfair dismissal, an employer not only needs to show that there's a genuine redundancy situation, which falls within the legal definition of redundancy, but also that it follows a fair redundancy process. So let's take a very quick look at the typical redundancy process. Now, I should stress that this is the process for individual redundancy consultation. If you're in the realms of collective redundancy consultation, which we'll touch on later, then there's another process to be aware of as well. But turning to the graphic here, step 1 is to consider and record the business rationale for a redundancy. This is often overlooked by employers who fail to properly apply their mind to whether there's a genuine redundancy situation that falls within the legal definition of redundancy. But this is a crucial first step in establishing the basis for a fair dismissal. Once the business case for a redundancy has been identified, the next step is to identify the pool of individuals who are at risk of being made redundant and, assuming it's more than one employee, establish a set of fair and objective selection criteria that will be used to select employees for redundancy from that pool. The next step is to meet with the employees who are at risk of redundancy and warn them about this, and then engage in individual consultation with each employee about the proposed redundancy of their role. And this can take place over one or more consultation meetings. Once the decision has been taken to make an employee redundant, then there'll usually be a final meeting to inform the employee of the decision, and after that the employer will issue notice of termination. If the employee challenges the decision, then there may well be an appeal. So that's the brief recap over and done with, and we'll turn to our first tricky issue, which is the business case. So the starting point is that there has to be a genuine business case for making the redundancies, and at a minimum it needs to fall within the legal definition of redundancy. It feels like I'm stating the obvious, but it's an all too common pitfall for employers to assume that any dismissals that take place in the context of a restructuring or a business reorganisation are redundancies, without really stopping to think about whether they fall within the legal definition of redundancy. What's required then is a solid business case, ideally that's backed up by evidence that the position is in fact redundant within the meaning of the statutory definition. In particular, employers should avoid relying on a trumped up business case in order to attempt to use redundancy to mask another underlying reason for a dismissal, such as poor performance, as a weak or essentially made up business case is quickly going to be exposed if the redundancy is challenged. So the key thing to remember, I think, is that it's the role rather than the person that should be the focus of any redundancy exercise. If the dismissal is challenged, then the employer will need to be able to show and convince the tribunal that there was a genuine business case for redundancy. And this will be a lot easier if the rationale for the redundancy is set out in contemporaneous documents, for example, board minutes, strategy papers, memos, etc., which set out the business case for redundancy and record the reasons why the company arrived at the decision that there is a redundancy situation. And equally important, of course, is to avoid a paper trail that contains anything that goes against that stated business case. For example, an email saying, once we get rid of this guy, should we hire in someone decent? So our next tricky issues relate to pooling and selection criteria. And on this slide, we'll look first at the difficulties in identifying an appropriate pool of employees from which to make selections for redundancy. And this is really important because if the employer doesn't identify an appropriate pool at the outset, any redundancies that flow from that are likely to be unfair. Employers have a fairly broad discretion to determine the pool, and it won't generally be open to challenge in the tribunal as long as the employer can show that it genuinely applied its mind to the composition of the pool and that the approach it took in doing that was reasonable. But one of the most common pitfalls for employers is to define the pool too narrowly. As a general rule, all employees doing the same or similar type of work should be included in the pool. So, for example, if the employer is proposing to make an administrator role redundant in a particular department, it should really think about including all the administrator roles in other departments and potentially at other locations within the pool of potentially redundant employees. The extreme version of a pool that's too narrow is the so-called pool of one, where a single employee is put at risk. And there's a temptation to do this where an employer thinks that an employee is doing a unique role. They're the only person in that position, so naturally they're the only person who should be put at risk. It is permissible to have a pool of one if the individual is genuinely doing work that there's a reduced need for and no one else is doing that. But employers need to think carefully about whether there are interchangeable skills. If employees in one department are made redundant because there's a reduced need for employees in that department to carry out that particular kind of work, but they can point to employees in another department who, although doing a different kind of work, it requires the same or a similar set of skills, they may well be able to argue that all of those employees should have been pooled together because they've got interchangeable skills. And this is particularly an issue with lower skilled employees, where it's more likely to be the case that one employee will say, okay, well, the guy in that department's doing something a bit different, but I'm more incapable of doing that as well. So you should pull us both together to make the redundancy, because either of us could do the job that's still here. Although there are legal risks, which we've just identified, so a risk that any dismissals could be regarded as unfair if the pool is too narrow, there are also commercial risks to consider if the pool is drawn too widely. Simply put, it puts more employees at risk. This makes the selection process more onerous, and it also means a greater amount of disruption for the business, because you've got a larger number of employees who are worrying about their jobs, so there's going to be a greater impact on staff morale and productivity, whilst everyone waits to find out what the outcome of the redundancy process is and whether they're going to be made redundant or not. And for this reason, we'll often work with our clients to sidestep the pooling stage altogether and just move straight to talking to the employees who have been provisionally selected for redundancy. Although there can be an increased risk of unfair dismissal in this situation, and by taking this approach, depending on the circumstances, it may be that that increased legal risk is outweighed by the advantages of avoiding the commercial risks of drawing the pool too widely. So now looking at selection criteria, the starting point is that selection criteria need to be fair and reasonable. And a fundamental requirement of reasonable selection criteria is that they are as objective as possible. Wholly subjective criteria, such as judging people on whether they have the right attitude or are the right fit for the business, increases the risk of a dismissal being regarded as unfair, and so should be avoided. Some potentially fair selection criteria are performance and ability, disciplinary record, length of service, the employee's attendance record. And it's legitimate for employers to attach weightings to each factor in the selection criteria, as long as it can justify why it's attached to those weightings. An employee's score against each of the criteria should, so far as possible, be supported by relevant documentation. This will be relatively straightforward for something like attendance, because the HR department will usually have a fairly detailed and up-to-date attendance record. But we often see employers running into difficulties when it comes to justifying low scores for performance. So a manager may give an underperforming employee a low score against performance as part of the redundancy exercise, but then the employee can point back to years of positive appraisals where poor performance has never been raised as an issue before, probably because the manager conducting the appraisal ducked the difficult conversation at the time on poor performance. But this is going to undermine the basis for selecting the individual for redundancy. Certain criteria can operate in a potentially discriminatory way, and that's something that employers need to be aware of. For example, length of service is a legitimate factor to take into account as part of a balanced set of selection criteria, but if you simply apply a last in, first out principle, that's a blunt instrument and is likely to be discriminatory on the grounds of age, because it will tend to favour older employees. Similarly, it's legitimate to take into account attendance record, but in order to avoid maternity discrimination, for example, any maternity-related absence should be disregarded. Likewise, employers should give careful thought to whether they need to adjust attendance scores for employees who are disabled and have had disability-related absence in order to address the risk of disability discrimination. Another common pitfall is lack of transparency, and employers being reluctant to share the scoring process with individuals. But the tribunal will be critical of an employer who fails to disclose to an individual their individual scores, explain how they were arrived at, and crucially give the employee the opportunity to challenge those scores as part of the individual consultation process. In at number 3, on our top 5 of collective issue is collective issues. So some of you will be aware that collective redundancy consultation is triggered when an employer is proposing to dismiss 20 or more employees at one establishment in a period of 90 days. So that's the test for collective redundancies. And there are lots of tricky issues with collective redundancies, and I think this could easily be a talk in its own right. So from the many possible tricky issues that I could have picked, I've picked 3. And the first of those is calculating the threshold, i.e. have you hit the 20 or more redundancies at one establishment in the period of 90 days? And the first issue is really a practical one, of making sure that there are systems in place to identify when this threshold has been reached. This is actually much easier now than it would have been a couple of years ago, when the Woolworths case disapplied the requirement for the redundancies to be at one establishment. Following that case, this meant that businesses with multiple sites had to keep track of redundancies at all those sites, because the threshold was whether there's 20 or more redundancies across the business. And it was easy for large employers to inadvertently trip the threshold and not engage in collective consultation and face penalties. The case law has now gone the other way, and the requirement for redundancies to be at one establishment has been reinstated. And so once again, the test is whether there are 20 or more redundancies at one establishment in a period of 90 days. But employers still need to make sure that they're not caught out by making sure that there are systems in place to flag when they might hit that threshold. Employers also need to know when calculating whether they're going to hit the threshold, which dismissals to take into account and which ones can be disregarded. And there are some nuances here to be aware of. Employees who take up an employer's offer of voluntary redundancy, for example, must still be counted towards the total. Employees whose employment ends on the expiry of a fixed-term contract, though, so it just comes to its natural end, and it isn't renewed because the employer is making redundancies, don't have to be included when tallying up the numbers. And that reflects a change in the law in 2013, which is worth being aware of. Dismissals that are already subject to consultation can be excluded. So, for example, if an employer is proposing to dismiss 50 employees as redundant, it starts collective consultation with those employees and then realises, actually, I think we need to add another 10. Those 10 can be viewed in isolation. It's not necessary to restart the whole collective redundancy process with them. But a word of warning here is that the tribunal is very alert to employers deliberately structuring redundancies in batches in order to fall below the 20 redundancies threshold, and employers who try to do this and get caught out face potentially significant penalties. There's also nuances to be aware of in the timeframes that can apply on collective redundancy consultations. There are minimum time periods that must be followed for notifying the government that you're making collective redundancies, and also the length of time that has to elapse between starting collective consultation and the first dismissals taking effect. And these vary depending on the number of redundancies that are being proposed. So for 20 to 99 redundancies, the relevant time period for each of those things is 30 days. But where there's a large number of redundancies, 100 or more, then this is extended to 45 days. The final potential pitfall that I'm going to look at in relation to collective issues is the danger of focusing only on the collective process. It's a very structured process, and it's easy to get carried away and a bit blinkered and focus just on that. But it's important to also remember that you need to conduct individual consultation with the employees as well. Both, if you're in the collective redundancy situation, both collective and individual consultation are required in order for the dismissal to be fair, and collective consultation is no substitute for individual consultation. Next, looking at enhanced redundancy payments. So, statutory redundancy pay is fairly modest. The maximum for the longest serving employees is less than £15,000. And so it's fairly common for employers, particularly in certain sectors, to offer enhanced redundancy payments. And these are usually linked to age or length of service. But the tricky issue here is that these kinds of enhanced redundancy schemes are potentially discriminatory on the grounds of age, because they tend to favour older workers. So the statutory redundancy pay formula is also discriminatory, because that also tends to favour older workers, but there's a specific exemption for it in the discrimination legislation. Now, this exemption also extends to enhanced redundancy payment schemes, but only if they are sufficiently similar to the statutory redundancy pay formula. And so the danger for employers is adopting an enhanced redundancy pay scheme that differs too much from the statutory formula, so that it falls outside the exemption, and therefore the employer is exposed to the risk of age discrimination. And if this happens, it will have to show a tribunal, if a claim is brought, that the enhanced redundancy pay scheme that it's put in place can be objectively justified. And if it hasn't really applied its mind to that at the beginning, it doesn't have the documents to show that it thought about how this scheme could be justified, then it's going to run into difficulties. So moving on, then, an inherently tricky issue in any context is tax and getting it right. And I think there's quite a common misconception that any payments made to employees on their redundancy can be made tax-free, but unfortunately it's not that straightforward. Broadly speaking, only termination payments that represent compensation for loss of employment qualify for a tax exemption, so not subject to income tax. And so this means that any payments made to a redundant employee, for example, payment in lieu of notice or payment in lieu of accrued holiday, that aren't compensation for loss of employment will be taxed in the normal way. The fact that they're made to an employee who's being made redundant is neither here nor there. Although redundancy payments do qualify for the tax exemption, it only applies to the first £30,000, which I'm sure is a figure that you've all come across before. And this means that any excess of the redundancy payment above £30,000 will be subject to income tax. Now, currently, national insurance contributions aren't payable on termination payments, but the law is going to change in April next year. And this means that termination payments in excess of £30,000 will be subject to income tax and employer national insurance contributions. So what I do is encourage anyone here who's got any exits on the horizon that will involve a larger termination payment to speak to us sooner rather than later about getting those exits concluded before the tax rules change next year, because otherwise those larger termination payments are automatically going to become more expensive when you have to pay employer national insurance contributions on them. So finally, the perennial issue, I guess, on redundancies, a tricky issue on redundancies, how to deal with employees on maternity leave. And the first step, really, I think, is to dispel the myth that employees on maternity leave can't be made redundant. That's not true. It's perfectly permissible to include employees who are on maternity leave in a redundancy exercise. There are just some extra considerations to be aware of. We've already looked at, or touched upon rather, some of the dangers of applying selection criteria in a discriminatory way, for example, taking into account maternity-related absence when scoring employees on their attendance record. But there are some other tricky issues to be aware of. The first is really a practical point, and that's how to communicate with an employee who is out of the office on maternity leave. There's a risk that employees who are out of the office are going to be out of sight, out of mind, and inadvertently excluded from the redundancy consultation process. And this is going to expose the employer to claims for unfair dismissal and also discrimination. So employers need to involve them in the consultation process, but also need to be sensitive about how they do that, and need to balance the need to keep the employee fully up to date with what's happening, but also respecting the fact that they've got family commitments. And so some adjustments to the process might be required for employees who are on maternity leave. For example, giving them more notice of meetings and allowing them to have meetings by telephone, for example, if that's more convenient for the employee. The next potentially tricky issue is to remember that when choosing between employees for any available vacancy, employees who are on maternity leave have an automatic right to be offered a suitable alternative role. And this essentially gives employees who are on maternity leave priority over other employees who are also at risk of redundancy. And that's a rare example of lawful positive discrimination in English law. And finally, if an employee is entitled to statutory maternity pay at the time that she's made redundant, then that entitlement continues. Her entitlement to statutory maternity pay isn't conditional on her remaining in employment. And so employers need to make sure that the employee receives their full quota of statutory maternity pay. Practically, rather than keeping a redundant employee on maternity leave on the payroll, it might be easier just to pay that as a lump sum. So that's a fairly whistle-stop tour of tricky issues in redundancy.